Let us first understand what do you mean by majority. Who is a major? Now here we are not talking about the rank of major in the army. Here we are referring to the age, majority by age. So a person is considered to be major if he is not a minor. And who is a minor? Minor is a person who is below 18 years old. He is not 18 years old yet. So if a person is not 18 years old, he will be called a minor. If he is 18 and beyond 18, all the persons will be called as majors. And this definition has been given under the Indian Majority Act 1875. Now this act or this logic has been stated because of two reasons. First, to protect the minor. Second, to prevent the hardship to adults. Now, why should a minor not be competent to enter into contracts? Why does a minor not have any capacity or competence to enter into contracts? Why should he be debarred from making contracts? These are the two reasons. These are the two principles because of which minors are not allowed to make any contracts. First is to protect himself, for the protection of the minor himself. The second is to prevent the hardship to the adults who are making contracts with him, or the adults who are related to him like his parents or guardians. So in both the cases, it is important that minors should not be allowed to make any contracts. So we can say minors are incompetent, they do not have the competence to enter into contracts, they do not have the ability or capacity to enter into contracts. Thus, we can say the contracts or the agreements with minors are void ab initio. Now, this is very important. Please get this thing straight in your mind. This is a very frequent question in the examination. A contract with minor is A valid, B void, C void ab initio, D illegal. So this is the kind of question that frequently comes in the examination. Please remember, all contracts with minors are void ab initio. Now, what do you mean by void ab initio? Void ab initio means void at initiation, that is void at the beginning, yeah, or void at starting. So when the contract initiates, when the contract begins, or when it starts, it is void since that time only. I'd like to take you back to the definition of a void contract. Do you remember the definition of void contract? Okay, I'll tell you. The definition says a contract which ceases to be enforceable by law is a void contract. A contract which ceases to be enforceable. The important word here is ceases. Now, why is this word important? Because a contract which starts off as a valid contract and later on ceases to be enforceable and later on ceases to be valid, that contract is called as void contract. But here I am saying a contract which is void since the initiation, which is void when it is made, when it begins at the start itself. It does not remain valid for some time and then later on it becomes void. No, it starts off as void only, and such a contract is called as void ab initio contract. Actually, this contract never becomes a contract. This remains an agreement only. So we normally say all agreements made with minors are void ab initio, because they never become contract. They never reach a stage of becoming contract because law does not enforce them. They do not get the support of law. So they stop at being agreements only. So please remember this, all agreements with minors are void ab initio. This principle was highlighted in the case Mohri Bibi versus Dharmodas Ghosh. Now this case was put up or initiated by Mohri Bibi. So Mohri Bibi will be called as plaintiff. So whoever is the plaintiff, his name appears first when you cite a case law. So if this person is the plaintiff, the person who responds is called as the respondent or the defendant. So what he does is he responds to the complaint filed by the plaintiff. So this is why he is called as respondent or defendant. Now let's take a look at this case. So there were two persons, Mohri Bibi and Dharmodas Ghosh. Mohri Bibi was an adult, whereas Dharmodas Ghosh was a minor. Now even though Dharmodas Ghosh was a minor, he wanted some money, but he did not have any means of income. So what he did was he projected himself as a major. And why did he project himself as a major? Because if he stood as a major, he owned a property. So as a major, he could mortgage that property. And he mortgaged his property in the favor of Mohri Bibi. A bond or a mortgage was instituted for 20,000 rupees, out of which 8,000 rupees were advanced by Mohri Bibi to Dharmodas Ghosh. Now please remember that Dharmodas Ghosh here is still a minor. He is only projecting himself. He has lied to Mohri Bibi that he is a major and has the capacity to contract. So he gets 8,000 from Mohri Bibi. Later on, when he asks for the full amount of mortgage, that is the remaining 12,000 rupees, Mohri Bibi comes to know that he is a minor. He does not have the capacity to contract. Thus, he does not have the capacity to put his property under mortgage. So whatever money I have advanced to him is almost unsecured. I don't stand to get any security out of the mortgage contract because that contract would be void. So she did not advance the balance 12,000 rupees. On the contrary, she asked her 8,000 advance back. On this, Dharmodas Ghosh said, I am not returning you your advance. So what she did was, she instituted a case against Dharmodas Ghosh. And therefore you can see that Mohri Bibi's name is appearing first and respondent, who is Dharmodas Ghosh, his name is appearing second in the citation of case law. So when this case was heard, Mohri Bibi presented her side, and then the court asked Dharmodas Ghosh to defend his case. So in that he said he is a minor. Before the court he pleaded his minority, and on this it was decided that since Dharmodas Ghosh is minor, he cannot enter into contract. And since he cannot enter into contract, the contract that he had made of mortgaging his property is null and void. It does not have any legal value or contractual value. So whatever mortgage has been created, it is of no value. At the same time, it was also held that the advance that Mohri Bibi had given to Dharmodas Ghosh, that would also be not returned because it was given to a minor. And whatever the minor gets under a void contract, he is not liable to return it. He is not liable to restore the benefit that he gets under a void contract, because whatever contract he makes is void ab initio rather, and whatever benefit he receives under that contract, he is not liable to return it or restore it. Please remember, if he was an adult, he would have had to return the advance that he has received, because if a normal major person enters into a contract and that contract later on goes on to becoming a void contract, so whatever the benefit any party has received under the contract has to be restored, has to be returned in normal circumstances. But this is not the case with a minor. A minor is not liable to restore the benefit received under a void contract. So these were the two highlights of the case. The first was any contract instituted by a minor is void ab initio. Second, any benefit received by a minor under a void contract, he is not liable to restore it. Now let's take a look at the position of a minor. These were a couple of things that we discussed. Now let's take a look at the position of the minor if he enters into a contract, or why a minor cannot enter into a contract.